Hello, and welcome to California Gun Law. I'm your host, Don Hammond. Good news! The feds are planning to revive a procedure to process applications to restore Second Amendment rights. That procedure has been dormant since 1992, and we get a lot of requests to restore rights. So let's take a look at this revived process. I am Don Hammond. I'm a licensed California attorney and a shooting instructor. I regularly help teach the 16-hour class that's required to get a concealed carry license in California. On this program, we provide education on California's complicated web of gun laws so the responsible gun owners like you can better understand how to lawfully exercise their rights. California has a complicated web of laws and regulations, and there are lots of traps for the unwary. We want to help you do it right so you won't need our criminal defense legal services. Today, I'll be discussing the Attorney General's withdrawal of a delegation of authority to ATF. Looks like this in the Federal Register. I know, this sounds complicated, right? Well, the history here is pretty wild. There are 9 categories of people listed in 18 United States Code, Section 922, Subdivision G, who are prohibited for life from possessing firearms. These include people who are convicted of felonies, dishonorable discharges from the military, being an unlawful user of controlled substances, and anyone convicted of a misdemeanor crime of domestic violence. That's right, even a misdemeanor can make you prohibited for life under federal law. Even if state law says these people can have guns, federal law keeps them prohibited for life. So there used to be a way to fix that under federal law. Back in 1968, Congress enabled the Secretary of the Treasury to provide relief to some people who had lost their gun rights. That authority was then expanded to apply to more people and transferred from Treasury over to the Attorney General, or the Attorney General's designee. The Attorney General then delegated that authority to the ATF back when it was created. Until 1992, the ATF was processing applications to restore gun rights. But in 1992, Congress decided that processing these petitions was too resource intensive. ATF was spending approximately 40 man-years annually to investigate and act upon the applications. Congress decided that these resources would be better spent cracking down on violent crime. Remember the tough on crime 90s? So they gutted the funding that allowed ATF to process these restoration applications. And ever since 1992, the ATF has been unable to process individual applications. They could still handle corporate applications, but those are very rare. So we went 33 years with no individual applications to restore rights being processed. None at all. Now, thanks to President Trump's Executive Order 14206, entitled Protecting Second Amendment Rights, which was issued back on February 26, 2025, the new Attorney General, Pam Bondi, has been looking at laws that impact Second Amendment rights. One that her team came across was this restoration of rights application process. So now, the AG's office has issued a rule taking the application process delegation away from the ATF and moving it back under the umbrella of the Attorney General. This avoids the funding rider from Congress that prohibits ATF from spending any resources on processing the applications. The new rule took effect immediately, back on March 20th, 2025, but there's still a public comment period until June 18th, 2025. I'll put a link in the show notes for those who want to submit a comment. It remains to be seen how the AG's office will process applications to restore firearms rights. The legal standard is codified in 18 United States Code Section 925, Subdivision C. It provides that a person who is prohibited from possessing firearms under federal law may apply for relief through the Attorney General. The AG may grant that relief if it is established that the circumstances regarding the disability, that's the facts of the underlying conduct, and the applicant's record and reputation are such that the applicant will not be likely to act in a manner dangerous to public safety, and that the granting of relief would not be contrary to the public interest. So we'll have to see how they apply that standard to actually restore people's rights and how often people are successful at getting their rights restored. The statute also provides for judicial review in district court if the Attorney General's office denies the application. But the logistics of where and how to file an application don't seem to be available yet. Should people fill out the ATF Form 3210.1 and FedEx it directly to Pam Bondi? I think the AG's office will have to create a new form and designate a process for submitting the application. So all of this is good progress, but we're still in limbo as to the actual process of getting gun rights restored under federal law. As this process continues and we make better progress and have more information about it, we'll try to keep you all informed. I'm Don Hammond at California Gun Law, and we'll catch you all next time. Stay informed, stay legal, stay safe.